The Supreme Court just issued a 6-3 emergency order that is already detonating across every level of American government. This is not a slow-burn cert grant that will simmer for months. This is a midnight, lights-on, drop-everything ruling that is reordering the relationship between the states and Washington before the ink is dry. Within minutes of the docket ping, governors were calling emergency cabinet meetings, DOJ litigators were canceling flights, and career clerks were pulling all-nighters to rewrite briefs that were supposed to be filed at sunrise. The reason is simple. The court has slammed the brakes on the single most powerful weapon the federal government has deployed against state laws in the last decade, the nationwide injunction. Tonight, we are going to unpack exactly what the court did, why it did it, and how every policy fight you care about, guns, borders, elections, the environment, even public health emergencies, just shifted into a new legal gear. If you want to understand the new rules of the game, stay locked in until the last sentence, because the precedent set tonight will be quoted in courthouses and law school classrooms for the next half-century. First, the raw facts. At 11:47 p.m. last night, the Supreme Court granted an emergency application filed by 26 states led by Florida and Texas. The states asked the justices to stay a single district judge's order that had blocked a state immigration enforcement statute from taking effect anywhere in the country. The district court had issued a 184-page nationwide injunction after a 2-hour Zoom hearing with only the named plaintiffs, 3 nonprofit organizations, and 2 undocumented individuals on the call. No other state, no other litigant, no intervening county, no member of Congress had been heard. Yet the judge enjoined the statute coast to coast, effectively vetoing a democratically enacted law in every courthouse from Miami to Seattle. The states told the Supreme Court that this kind of imperial edict is exactly what the framers feared. Unelected judges acting as a super legislature for 330 million Americans. The federal government countered that the state law conflicted with federal immigration supremacy, and that anything less than a universal ban would create a crazy quilt of enforcement. 6 justices were unpersuaded. In a crisp 7-sentence order, they stayed the injunction except as to the 5 individual plaintiffs. 3 justices dissented, and with that, the era of the automatic nationwide injunction entered hospice. Now, let's zoom out and see why this is earthquake-level stuff. For the last 15 years, nationwide injunctions have become the go-to lever for whichever party is out of power. When President Obama announced DACA, Texas convinced a Brownsville judge to freeze the program nationwide. When President Trump tried to unwind DACA, blue state AGs flipped the script and got their own coast-to-coast order to keep it alive. The travel ban litigation produced 45 separate nationwide injunctions in 6 months. Environmental groups have used them to shutter pipeline projects from West Virginia to Wisconsin. Gun rights plaintiffs have used them to force shall-issue permit regimes on states that never voted for them. The pattern is always the same. Find a friendly single judge, file a 20-page complaint, seek a temporary restraining order with a briefing schedule shorter than a Netflix binge, and presto, you have nullified a statute that survived committee hearings, floor debates, governor's pens, and often statewide referenda. The merits appeal will take years, but the policy is frozen in amber on day 1. That playbook just died. The court's order last night is only 6 sentences, but it explicitly cites 2 recent opinions, Trump versus Sierra Club and Labrador versus Poe, in which the justices warned that equitable relief must be tailored to the plaintiffs. Lower court judges who spent the last decade issuing universal vetoes now have to confront a crystal-clear Supreme Court signal. Tailor your remedy or see it stayed within hours. The conservative justices have been telegraphing this for years, but last night they finally pulled the trigger on an emergency docket. The liberal justices dissented with a single paragraph that warned of chaos and piecemeal enforcement. Yet even they did not defend the nationwide injunction on the merits. Instead, they argued only that the court should wait for full briefing. That tells you how much the intellectual ground has shifted. The debate is no longer whether nationwide injunctions are legitimate. It is how quickly they will be interred. Justice Gorsuch penned a separate concurrence that reads like a manifesto. He traced the history of equity from the Chancellor's foot to the federal rules, reminded readers that the Constitution never conferred roving commission to rewrite laws, and closed with a line that will be block-quoted in every brief for the next decade. A court may no more enjoin the world than it may adjudge it. Translation: if the plaintiffs are 5 people in Waco, the remedy runs to 5 people in Waco, not to 254 counties or 49 other states. Gorsuch's punchline is that the separation of powers is not a stylistic preference, it is a structural firewall. When district judges act like mini-presidents, they collapse the distinction between judicial power and legislative power, and they do so without the democratic legitimacy of either. The concurrence is only 4 pages, but it is the intellectual cornerstone that future litigants will quarry for quotation. Justice Sotomayor's dissent, joined by Justices Kagan and Jackson, fires back with a pragmatic worry. If every state can enforce a questionable law while piecemeal litigation percolates, the result will be a balkanized republic where rights depend on geography. She sketches a nightmare scenario in which a vaccine mandate is enjoined in the Northern District of Florida but remains in force in the Middle District of Georgia, creating a commuter's patchwork of liberty. She warns that the court's stay tips the scales of justice toward the states and against individual rights. Yet even her dissent concedes that the majority has the vote, and she implicitly invites Congress to legislate a rule governing the scope of injunctions. That concession is monumental. It signals that the nationwide injunction now lives on borrowed time. Within minutes of the order, the political shockwaves began. Florida's governor called an impromptu 12:30 a.m. press conference on the Capitol steps, flanked by half the cabinet, to declare that the ghost of nationwide activism has been exorcised. Texas announced that its dormant border fencing statute will go into effect at sunrise and that it will file copycat motions at 5 pending immigration suit. California, suddenly on the other side of the sword, pulled its own nationwide request in a gun case pending in Sacramento and replaced it with a plaintiff-specific plea. The White House released a terse statement at 1:15 a.m., saying it is reviewing the implications and will continue to defend federal supremacy. Translation: we just lost our favorite weapon, and we have no immediate replacement. Career DOJ lawyers privately told reporters that dozens of templates will have to be rewritten and that the Solicitor General is convening an emergency moot court session before sunrise. One line attorney called it the legal equivalent of losing air superiority. Let's look at the immediate fallout by policy area. Immigration. The original statute allowed state judges to issue removal orders if the federal government declined to take custody of an arrested non-citizen. Under last night's order, that provision is live in Florida, Texas, Alabama, and every other state that wants to copy it, except as to the 5 individual plaintiffs who can still seek a personalized exemption. Gun rights. 3 pending cases seek to enjoin Illinois' new assault weapon ban nationwide. Expect every one of those requests to be narrowed to the named gun stores. Environment. A Montana district judge had enjoined the entire Bureau of Land Management grazing rule. That order will shrink to the 2 ranchers who sued. Election law. A pending Georgia case that would have rewired signature verification rules for every county will now apply, if at all, only to the 4 voters on the caption. The states, for their part, are not wasting the moment. By 3:02 a.m., the Republican Attorneys General Association had blasted a memo to every member office with a cut-and-paste motion to dissolve any nationwide injunction currently on their books. The memo quotes Gorsuch's "injunct the world" line no fewer than 6 times and includes a color-coded map showing which districts are still friendly and which are now no-go zone. Democratic AGs are scrambling for counter-memoranda, but the intellectual cupboard is bare. The Supreme Court just shut off the spigot. Expect a tidal wave of motion to narrow filings by sunrise, followed by emergency stays when district judges try to resist. The appellate courts will then have to apply the new standard in real time, with every denial almost certainly heading to the Supreme Court on an emergency docket that is already clogged. The phrase litigation explosion is overused, but if ever there were a moment for it, this is it. Expect a tidal wave of motion to narrow filings by sunrise, followed by emergency stays when district judges try to resist. The appellate courts will then have to apply the new standard in real time, with every denial almost certainly heading to the Supreme Court on an emergency docket that is already clogged. The phrase litigation explosion is overused, but if ever there were a moment for it, this is it. Constitutional scholars are already calling the order the most significant curb on equitable power since Ex parte Young in 1908. Professor John Harrison at Virginia posted a midnight blog titled "The Day Equity Died," arguing that the court has restored the traditional rule that injunctions are remedy, not legislation. Professor Amanda Diana Frost at American countered with a thread warning that rights without universality are privileges, predicting that Congress will be pressured to create an express statutory authorization for broader relief. Both agree on one point. The separation of powers revolution that began with the major questions doctrine has now swallowed the judiciary itself. The court is no longer content to police agency power. It is policing its own brand. Zoom out again, and you see the deeper pattern. Last term, the court told agencies they need clear congressional authorization for major initiative. Earlier this year, it told Congress that delegation must come with intelligible principle. Last night, it told district judges that equitable power is personal, not planetary. Add those three moves together, and you get a court that is systematically dismantling every workaround the political system invented to avoid the hard work of legislation. The alternative was a system in which one unelected judge could govern 330 million people without debate, amendment, or accountability. Last night, the court picked door number 2. Whether history calls it chaos or constitutional restoration will depend on how quickly Congress and state legislatures step into the vacuum and do their jobs. If you have hung around this long, you now understand why every policy war room in America is still awake. The nationwide injunction, the ultimate legal cheat code, has been deleted from the console. The court's 6-3 order is short, but its aftershocks will ripple through immigration dockets, gun cases, environmental rulemaking, voting rights suits, and public health orders for the next generation. The message is unmistakable. If you want to change the country, win elections, pass laws, and build coalitions, the courthouse door is still open, but the nationwide magic wand is gone. That is not just a technical tweak, it is a regime change, and regime changes are never quiet.